Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's episode of Legal Scrubs, where I discuss business issues of significance and interest to health professionals, doctors, dentists, and other healthcare professionals. And so today I'm going to talk about one of the most important provisions in an employment contract between a doctor and its employing entity, whether it's a hospital or a group practice or whatever it is. This is one of the most important provisions to look out for and pay attention to when you, the doctor, are negotiating your employment contract with your employer. And that provision involves tail insurance, malpractice insurance that comes into play when you leave your employment with your employer. It's called tail insurance, and you probably are familiar with it to some extent, but here's why it's important. If you have an employment contract with, let's say, a group practice, and at some point the group practice decides to part ways with you and essentially terminates your employment, who pays for the cost of your tail insurance? Now, you need to have tail insurance, obviously, because most malpractice insurance policies these days are what are called claims-made policies. And what that essentially means is that if you have an event that gives rise to a malpractice lawsuit that occurs during your employment with the group practice, but the claim, the case, is not filed until sometime after you've left your employment by the group practice, the insurance only kicks in, only provides you with protection if it is in force or in effect at the time the claim is made. It doesn't relate back to the time or the date when the event that gives rise to the claim occurred. That used to be common for malpractice insurance policies to be what are called occurrence policies. If you had an occurrence malpractice policy or occurrence-based malpractice policy, then as long as the policy were to be in effect at the time that the event occurred, you would have coverage whether or not you were still employed by that business and it was providing you with the malpractice coverage. But that's not the case really anymore. Occurrence-based malpractice policies are essentially very expensive, too expensive these days for most healthcare entities, group practices, hospitals, whatever, to provide occurrence-based malpractice policies for their doctors. And so most malpractice policies are what are called claims-made policies. And so the policy needs to be in effect at the time or the date that the claim is made, not the time that the event occurred that gives rise to the malpractice claim. And so if you are working at a group practice and an event occurs that may at some future point give rise to a malpractice case, if that policy is no longer in effect at the time the claim is made because you've left the group and that policy no longer is in effect for you, unless you have what is called tail insurance that provides coverage to you after you have left the group and no longer have that particular policy, then you don't have coverage. It's essentially called tail coverage because it comes at the tail end or at the conclusion of the normal period of time that the policy is in effect. It's essentially an endorsement that is written by the insurance carrier to provide coverage after the fact, after the date that the original policy is no longer in effect. And tail coverage is generally fairly expensive. Now, it varies in price based obviously on what is the specialty of the physician, whether you're a family practice doctor or whether you are an OB, or whether you're a dermatologist or a surgeon, as the exposure increases because of the specialty, the price of the tail policy goes up. Also, the period of time that the doctor has been in practice, that you've been in practice, as the number of years go up, and you've been in practice longer, the policy price for the tail insurance goes up. So the least expensive tail policy coverage, or premium for a tail policy or tail endorsement, is going to be for probably like a family practice doctor, someone who's not doesn't have a high exposure specialty necessarily, doing a lot of procedures and things that provide really more risk to the doctor for a malpractice claim. If you're a general practice doctor, a family practice doctor, and if you've only been in practice for a year or two or three, your premium is going to be a lot less than, let's say, a surgeon who's been in practice for 10 or 15 years. Would his or her premium would be. Now, when it comes to negotiating your contract, you want to look very closely at a couple of things. First, what are the termination provisions in your contract? Can the group practice terminate your employment or fire you without cause, for no reason? And if so, who pays for the tail coverage? Can you be terminated only for cause? And is the cause spelled out so that it's something that you would expect to be the kind of thing that would give rise to a termination, like you lose your medical license, or you're convicted of a felony, or something like that, or you're no longer eligible or approved to be a Medicare provider, or you are uninsurable for some reason. If the termination provisions of your contract are broad enough that the group practice can basically get rid of you for no reason, or for a very vague, maybe easily raised objection like disruptive to the office or something like that, and if you have to pay for your tail insurance on that kind of termination, that's a problem, because if you are let go for very little reason or no reason, and you have to pay your tail insurance, it's a big hit, because it could be tens of thousands or more in cost to provide the tail coverage. So you want to try to negotiate with the group practice to have the group practice bear the cost of your tail coverage, as to the extent that you are able to do so. If you can get the group practice to agree to provide the tail coverage premium in the event that they terminate you without cause, that's a plus. If you then look at what are the reasons for cause and make sure they're not amorphous and vague and would allow the practice to terminate you for a very little reason, like disruptive to the office or something, and then have you pay the tail coverage, you want to look at that as well. Now, it's the case typically that your employer, your group practice in this example, is going to want to have you be insured, because if you get sued after the fact, after you've left, they are going to get sued too, and they're going to want to have coverage. And so, this is the kind of thing you really can negotiate, because if you just say, look, if I'm going to have to pay for this tail coverage, I'm not sure I can afford it. I may just have to go uninsured for the period of time that would relate to when I was employed by you. That might be a negotiating tactic that would allow you to get the employer to perhaps pay the cost of your tail coverage. You might have another possibility is to provide in your contract that you would, if you leave at a certain short period of time after going to work for the group, and it's a termination for cause, and you limit the causes to something that's really significant, and you say, well, I'll pay the tail coverage if I leave for cause within a year or two from the outset of the employment agreement. But if I'm here for more than 2 years or more than 3 years, you will pay for it, you employer. or will share the cost of it in some manner. But the whole point is that the termination provisions and the tail insurance provisions working together are one of the most significant parts of an employment agreement between a doctor and the group practice or hospital that is employing that doctor. Another thing to look at is if you're at the sort of the end of your career as a doctor and you're going to probably work at this group until you retire, and you're not looking necessarily only at a termination situation, where either a termination for cause or a termination without cause, but you're also taking into account you may just want to retire and stop practicing medicine altogether. You need to see how the cost of that premium is covered at your retirement, because even after you retire, if there's an event that occurred while you were employed as a doctor and you have a claims-made type of insurance policy, which you almost certainly will have, you could still get sued even in retirement, assuming that the plaintiff has filed it within a timely manner, within the statute of limitations, and all the things that go into filing a lawsuit have been complied with. But you could still be sued in retirement, and you want to make sure you have tail coverage that covers you sufficiently during this period of time at retirement. So you want to look at your contract and make sure that if you do retire under your employment contract, that your employing entity is going to provide the cost of your tail insurance. And again, they're going to want to have coverage for you just because they're going to get sued as well. This is the kind of thing you should be able to negotiate with your employer, especially with respect to a retirement situation. All right, that's about it for today. I hope that helps. If you have a question, please feel free to contact me. You can check me out, get contact information on my website, dpslegalcounsel.com. You may find something on there that's of interest to you, a video, a blog post. If you have a question in particular, please feel free to reach out and let me know. If you want to subscribe to the firm newsletter and get updates and tips sent to you on a regular basis, please feel free to do that on the website. And that'll be about it for today. I hope it helps, and we'll see you next time on Legal Scrubs.